5 seconds to go. Start. We are faced with a case of patricide, albeit both the father and the son were drinking together. In the intervening night of 26th and 27th July 2010, between 10 pm and 12:30 pm, the effect of alcohol may have resulted in a quarrel inter se the father and the son. The informer, Chamru Ram, PW8, who is a neighbor, on reaching their house, found the appellant assaulting his father, the deceased, with nagar wood. The deceased fell to the ground and died. In the presence of the appellant's brother, PW4, the appellant admitted that he killed his father. The FIR was lodged by PW8 in the police station Darima next morning, and the appellant was arrested on 28th July 2010. On his disclosure statement regarding a lungi as well as nagar wood, the same were found at the courtyard of his house and then sent to Forensic Science Laboratory, Raipur, for chemical examination. It is necessary to set out the result of the autopsy, which opined that the injuries on the dead body were caused by some hard and blunt object between half to 2 hours of death. These injuries were stated to be fatal to life and sufficient to cause death to the deceased. On an internal examination of the dead body, alcohol was found present inside the deceased's stomach. The cause of death was stated to be hemorrhage shock caused by the fatal injuries to the vital organs, and death was homicidal in nature. On completion of investigation, a charge sheet was filed before the Judicial Magistrate First Class Ambikapur, who committed the case to the Court of Sessions. Charges were framed under Section 302 of the Indian Penal Code, hereinafter referred to as the IPC, on 8th March 2011, and the prosecution examined 10 witnesses. The appellant pleaded innocence in his statement under Section 313 of the Code of Criminal Procedure, hereinafter referred to as the CRPC, but admitted that he and the deceased were residing together in the same house. The learned additional sessions judge, void the judgment dated 15th October 2012, convicted the appellant, finding him guilty of causing a homicidal death amounting to murder under Section 302 of the IPC, and sentenced to undergo RI for life with a fine of rupees 1000, and in default to undergo additional RI for 4 months. It was opined that the case of the prosecution was based on direct evidence, judicial confession, seizure based on appellant's statement, and on circumstantial evidence that the body of the deceased was found in the appellant's house. On appeal being preferred before the High Court, the same was dismissed by the impugned judgment dated 8th April 2015. The evidence was analyzed threadbare, including the statement of neighbors who were prosecution witnesses stating that the appellant and the deceased were residing in the same house, and on being informed about the death of the deceased, they went to the house and saw the dead body of the deceased. Stop.